Welcome again to the Melling Law YouTube channel. Today we're continuing our series about when to update your Utah estate plan. Today we are specifically talking about the death of a spouse. Now, most estate plans, if they've been prepared by an experienced estate planning attorney, are going to still hold up if a spouse has passed away. However, many of them will not. This is especially true for people who are maybe on the verge of needing a trust, but not quite, but both spouses were perfectly healthy. They might have just done a will-based plan. If one spouse passes away, then it is imperative that the surviving spouse get some kind of a trust in place if there's any real estate available in the estate, because otherwise it's going to force the estate into probate if that surviving spouse passes away. Another common thing that might affect is just the joint tenancy of property. If you have any real estate and it's held in husband and wife's name as joint tenants with right of survivorship, if one passes away, then the survivor is the sole owner of that property. So if you want anybody to be able to administer the estate effectively, or you might not want to be the sole owner for whatever reason, or you want it to be in a trust, then that needs to be taken care of. A few other things with the death of a spouse is the possibility of remarriage. So if there's any kind of possibility of remarriage at all, we need to really make sure that the estate plan is really tight, that it is not going to be impacted by a future marriage, and that can be done fairly easily before a marriage takes place. After a marriage, it's much more difficult to do that. So if you want to protect your children's inheritance rights in any way as to a new spouse, then then you really do need to get an estate plan revised. And then finally, the estate plan often has, and we never do ours this way, but I notice many other attorneys will, or an online service or a do-it-yourself type of service will do this, where the spouse is the healthcare decision maker, the power of attorney, the personal representative on the will, and there's no backup person in place. There's no contingent person to fill that role. So if you're incapacitated and your spouse has passed away and they were your only power of attorney, then your children or other loved ones are going to have to go to court to get a conservatorship to be able to manage your finances unless you get your estate plan updated. So that kind of to sum up, if you have had a spouse pass away, or a loved one has had a spouse pass away, be sure to go to have them go, or you, if it's happened to you, to get your estate plan updated, because most estate plans, unless they were prepared by an experienced estate planning attorney, really need to be revised after the passing of a spouse. Thanks for watching. If you have any questions, you can reach out to us at any time.